May will court rise.
A reminder, when heard in the Crown Court at Leicester, this case was subject to reporting restrictions made pursuant to the provisions of Section 45 of the Youth Justice and Criminal Evidence Act 1999. The offender and his co-defendant were under the age of 18 years. Consequently, the registrar listed this case anonymously under randomly assigned initials. We have received submissions from both counsel. As a result, we confirm that this order continues in these proceedings. We also make an order subject to Section 45A of the Youth Justice and Criminal Evidence Act 1999, which prevents any report containing any information which may lead to the identification of either the offender or his co-defendant while they are respectively still minors or until further order. The two applications before us relate to the unlawful killing of Mr. Bhim Kohli. His Majesty's Solicitor General seeks leave to refer the sentence of 7 years detention handed down to the offender on 5th June 2025 as unduly lenient pursuant to Section 36 of the Criminal Justice Act 1988. The offender seeks permission to appeal his sentence as manifestly excessive. Introduction. The offender is now 15 years old. He was 14 years, 11 months old when he killed Mr. Kohli. The female co-defendant, referred to hereafter as Co-D, was 12 years, 8 months old at the time. Both were convicted after trial before a jury presided over by Mr. Justice Turner in the Crown Court sitting in Leicester. The co-defendant was convicted of manslaughter as participant in a joint enterprise. The offender had been charged with murder, but was acquitted of that offence and convicted of manslaughter instead. As already indicated, he was sentenced to 7 years detention. The co-defendant was sentenced to a youth rehabilitation order for 3 years with community requirements. She was significantly younger and had offered no physical violence to Mr. Kohli. Mr. Jarvis, King's Counsel, appears on behalf of His Majesty's Solicitor General. Mr. Bartier, King's Counsel, and Mr. Varley appear on behalf of the offender. We should say that we will refer to the offender as the offender, albeit considering both the applications of His Majesty's Solicitor General and that made on his behalf for permission to appeal against sentence, in which he would otherwise be referred to as the applicant. The facts. In the late afternoon of 1st September 2024, Mr. Kohli was walking his dog in a local park. He was an active 80-year-old, but slight in stature, described by the judge as, quotes, slim, ellipses, but fragile, and he looked his age, end quotes. The offender and co-defendant were in the park at the same time with some of their friends and associates. The co-defendant pointed Mr. Kohli out to the offender as someone who, it was alleged, had previously threatened a boy they knew with a stick. The offender put on a balaclava, obviously in order to hide his face, and walked over to Mr. Kohli. He confronted Mr. Kohli and knocked him to the ground. He then took off his shoe, which was a slider, and started to hit Mr. Kohli around the head as Mr. Kohli tried to get back to his feet. The co-defendant, who was laughing throughout, recorded this attack on her mobile telephone. Mr. Kohli got back to his feet and made his way to the entrance to the park, where the offender attacked him again. The offender pushed him to the ground a second time and then set upon him. He punched and kicked Mr. Kohli to the side of his chest, which was found to have broken 3 of his ribs. The co-defendant again encouraged the attack and filmed it. The offender and co-defendant then made off from the park, bragging about what they'd done. Mr. Kohli later died from his injuries caused by his fall to the floor on the second occasion. An autopsy confirmed that, quotes, the immediate cause of death, ellipsis, has been a neck injury causing trauma to the spinal cord. The spinal cord carries nerve signals to and from the brain supporting basic vital functions. Such damage can also lead to spinal shock, end quotes. The offender was arrested and interviewed on 3rd September 2024. He answered no comment, but in a prepared statement claimed that he had acted at all times in defence of his co-defendant. She was arrested and interviewed on the 2nd and 3rd of September 2024, but denied that she'd intended to assist or encourage the offender to attack Mr. Kohli. These stances were maintained during the trial that followed. Mr. Kohli was a much-loved husband, father and grandfather who was held in very high regard by the local community. He was fit and active and enjoyed quiet pursuits. His family, understandably, have been left devastated by his death. Having listened to their impact statements, in his sentencing remarks, the judge said, quotes, their grief and anger will cast a long shadow over their lives, end quotes. The offender had no previous findings of guilt recorded against him. The author of the pre-sentence report, prepared in May of 2025, recorded the concerns of the secure children's home in which he had been remanded concerning his mental health and undiagnosed learning needs. He's received specialist support from a speech and language team subsequently. A clinical psychologist and intervention focused themselves on regulating anger and emotions. Prior to remand and since birth, he'd been cared for by his mother, a single parent who was limited in her parenting capacity for significant periods of time by her own addiction to alcohol and subsequently serious ill health. The offender was bullied at school and withdrawn and home educated. His undiagnosed learning needs meant that he was unable to transition back into mainstream education. Consequently, he was somewhat socially isolated. However, the author of the report found that the maturity of the offender was commensurate with his age. The author considered that the offender's behaviour towards Mr. Kohli was, quotes, largely motivated by the gain of kudos among his peers present at the time and an inability to control his emotions in the moment, end quotes. The author regarded the real possibility that the offender may, quotes, associate with negative peers which could influence future behaviour, end quotes. He was, quotes, more vulnerable to reoffending and criminal exploitation, end quotes, because of him missing significant amounts of education and his undiagnosed learning needs. The risk of the offender reoffending was determined to be medium. Sentence. The judge addressed the defendants appropriately according to their age and level of understanding. He said as follows, quotes, what I have to say is mainly to you rather than to the lawyers or the adults who are listening to this, so I'm not going to use complicated language, end quotes. The judge found that the offender wore his balaclava, quotes, to make yourself look frightening and to hide your face so that you would not be recognised, end quotes. The offender, quotes, wanted to confront Mr. Kohli mainly because, square brackets, he was, close square brackets, showing off to, square brackets, co-D, close brackets. You knew that she was watching and that she was likely to take films on her mobile phone. I am sure that you knocked Mr. Kohli to the ground and then hit him to the head with your slider as he was on his knees, trying to get up. D2 recorded you doing this. I am sure that Mr. Kohli did nothing at all to deserve it. What you did was wicked, end quotes. The co-defendant had found this funny and laughed when it happened. The second attack was near the exit to the park and was, the judge thought, quotes, worst. end quotes. The offender had used a, quote, full force shove, end quote. The offender was, quote, again showing off and ellipses, lost your temper, end quotes. New quotation. You said that you had intended one hit, but then your anger turned in, ellipses. I am sure that you punched him. His neck was broken in the fall, and you then repeatedly kicked him hard in the ribs, ellipses. I am also sure that your intention, albeit for a short time when you lost your temper, was to cause Mr. Kohli injuries that, though not so serious as to need hospital treatment, were bound to be close. I am also sure that it ought to have been obvious to you that, whatever you intended, there was a high risk that what you did to an 80-year-old man would cause him really serious injury, ellipses. After the attack, ellipses, you were boasting to your friends about what you had done and pretending that you would bravely come to the rescue of the Kohli. In fact, as you well know, you made a cowardly and violent attack on an elderly man, end quotes. The judge was satisfied that the offence fell into Category B of the Sentencing Council's sentencing guideline for unlawful act manslaughter. For an adult offender, that meant a starting point of 12 years custody with a range of 8 to 16 years. Thereafter, the judge determined that there were aggravating features, namely, first, during the course of the attack, not find that the offender attacked Mr. Kohli because of his race, quotes, it was a lazy but very hurtful insult, end quotes. 2, Mr. Kohli was in very severe pain from his broken neck. 3, Mr. Kohli was vulnerable because of his age, although the judge was careful not to double count an aspect of culpability already determined. 4, planning. 5, 2 separate violent outbursts. 6, use of shoe as a weapon, quotes, but I bear in mind having seen that it was a flimsy item which, when used, was more humiliating than dangerous, end quotes. 7, as between you and Kohli, you took the lead in her presence, playing up to her and to the camera on her mobile phone. The mitigating features the judge found were 1, no previous convictions, 2, recent positive behaviour, 3, mental health issues as referred to in the pre-sentence report and referred to before in this judgment, 4, unsettled home life. The judge, however, was unable to give much weight to what is said, or was said, about his remorse. Quotes, had you been an adult, even concentrating as I must on your personal circumstances, the balance of aggravating and mitigating features would have resulted in an increase from the starting point to 14 years custody, end quotes. The judge then had regard to the guideline on the sentencing of children and young people. He said, quotes, I reduce this to 7 years to reflect your age and level of maturity and in conformity with the sentencing guideline. You will get credit for the time you've already spent in custody. This is one of those rare cases in which long-term detention is the only way to deal with you. A community order would simply not begin to reflect the seriousness of what you did, end quotes. The case was listed again on the 24th of June 2025 as the prosecution requested the judge should indicate the extent to which he'd uplifted the offender's sentence to reflect the racist element. The judge said this, quotes, but for the element of racial aggravation, I would still have reached the conclusion that the aggravating features outweighed the mitigating features, although not by as much, and I would have come to the conclusion that a total of 13 years would have been appropriate. That would have meant that the sentence on him, but for the racially aggravating feature, would have been 6.5, and therefore there was an extra 6 months attributable to the comments that he made during the course of committing the offence. That reflects the fact that the offence would have occurred anyway, but that there is an absence of any evidence that D1 was saying this in knowledge of anything that had happened to Mr. Kohli before, or indeed that he was saying that as the motive for his attack. Therefore, it comes at the lower end. I've also borne in mind in analysing this that the overwhelming culpability factor, of course, is the fact that someone died, and I have to bear in mind the question of proportionality in terms of assessing that aspect of it, that the element of racial aggravation contributed to an increase in the offender's sentence of 6 months." End quotes. The submissions. Mr. Jarvis submits that the judge determined that there were 2 high culpability factors: subjective, that is, an intention to cause harm falling just short of grievous bodily harm, and an objective assessment of risk, that an unlawful act carried a high risk of grievous bodily harm that was or ought to have been obvious to the offender. However, Mr. Jarvis says, the judge did not reflect, as he should have done, that the combination of factors therefore elevated the offender's culpability into the highest bracket, as occurred in the case of Attorney General's reference, brackets, the Crown against Parry, close brackets, 2023 EWCA Crim 421, semicolon, 2023 2 Criminal Appeal Reports, Sentencing 35, at paragraph 29. He goes on to say that the notional upward movement from the starting point of 12 years for a high culpability offence to 14 years was entirely driven by the resolution of the aggravating and mitigating factors. If the judge was not minded to increase the categorisation of high to very high culpability, there should have been a substantial upward adjustment to the starting point to reflect the presence of both the objective and subjective high culpability factors before considering matters of aggravation and mitigation, even if those factors in combination did not propel the case into the very high culpability bracket. Mr. Bartier and Mr. Varley concede that upon the findings, the categorisation of culpability at level B was correct, and that, quotes, "There is nothing wrong with how the judge structured his sentence, nor with the reduction of a half on account of the offender's youth. However, it is submitted, it may be thought to be arguable that the sentence of 7 years for a boy, still only 15 years old, is manifestly excessive." End quotes. The uplift for the identified aggravating features was, they submit, too high. Upon a closer analysis, they would not themselves justify an uplift of 1 year to the starting point. The additional increase for the element of racial aggravation by reason of the Sentencing Act section 66, subsection 4A1, and the guidance that is given, provides that, quotes, "The extent to which the sentence is increased will depend on the seriousness of the aggravation," end quotes. And limited in scope or duration. Consequently, and in accordance with the Sentencing Council's supplementary information regarding hate crime, the aggravation may be regarded as less serious, and therefore the judge, although taking an appropriate starting point, had made twin uplifts, which in this instance were too great. He gave too slight a discount for the mitigating features and did not properly consider the primary aim of sentencing youth offenders, that is, the prevention of further offending, in his case, by rehabilitation. While custody was inevitable and of some length, a sentence of 7 years for someone who was still only 14 at the time of the offence was, quotes, "a very significant sentence," end quotes. Discussion and conclusions. His Majesty's Solicitor General's application is founded on one issue, as we have indicated. Mr. Jarvis cites Parry as authority for the principle that the determination of subjective intent and objective risk when considering categorisation are not necessarily, quotes, "two sides of the same coin," end quotes. Therefore, in that the judge made findings that both subjectively and objectively really serious harm falling just short of grievous bodily harm was either respectively intended and or obvious, it may have attracted an upward shift in categorisation to very high culpability, or at least should have led to an increase from the starting point to the highest level in the range of sentences as indicated in the sentencing guideline for high culpability offending. We agree that there may be such cases, although, unless for the extreme character of one or other, as for example in the case of Parry, we find some difficulty in imagining that where subjective intent and objective risk coincide exactly, the combination of these two factors would alone lead to such a situation. We have considered with counsel whether the judge's sentencing remarks regarding his findings as to subjective intent does amount to a finding of an intention to cause harm falling short of grievous bodily harm. We accept Mr. Jarvis's submissions that although ambiguous, they should be seen in the context in which they appear, in which the judge was clearly addressing factors of high culpability. Mr. Bartier does not seek to argue the contrary to this point. His submissions in response to the application to make the reference focus upon the necessity to have regard to the circumstances of the case to achieve the correct categorisation of culpability, and not to fall into a mechanistic application of counting the number of culpability factors to do so. Ultimately, we have concluded that in this case, the findings of the judge do reveal two sides of the same coin. In those circumstances, there can be no realistic criticism that the judge failed to recategorise the offender's culpability as very high, or otherwise found it unnecessary to move up the range of sentences in the high culpability range. The circumstances of this case are not remotely akin to those in Parry. As identified in the Crown against Prajapati, 2024, EWCA 464, at paragraphs 41 to 46, the judgment in Parry cannot be read out of context. The assessment to be made of the extreme nature or combination of culpability B factors is fact-specific and should be nuanced, not mechanistic. Realistically, subject to what he suggests should have been at least an uplift in the starting point within the range of sentence advocated by the sentencing guideline, maintained at category B, high culpability, Mr. Jarvis does not suggest that the uplift of 2 years was insufficient after balancing aggravating and mitigating features. We agree with the judge that this was a wicked offence perpetrated by the offender against an elderly, frail man for no good reason other than to seek kudos with his peers. There is no question but that a significant period of retention was warranted. We understand that not only Mr. Kohli's family, but also many members of the public would have been shocked at what would objectively seem to them to be a lenient sentence of 7 years. However, the sentencing of children and young people for serious offences such as this is a complex and delicate exercise. It must be carried out in accordance with received and informed expert opinion as embedded within the Sentencing Council overarching guideline, sentencing children and young people. Specifically, the judge must bear in mind that, quotes, children and young people are not fully developed and they have not attained full maturity. As such, this can impact on their decision-making and risk-taking behaviour. It is important to consider the extent to which the child or young person has been acting impulsively and whether their conduct has been affected by inexperience, emotional volatility, or negative influences. They may not fully appreciate the effect their actions can have on other people and may not be capable of fully understanding the distress and pain they cause to the victims of their crimes. Children and young people are also likely to be susceptible to peer pressure and other external influences, end quotes. See Guideline 1.5. We consider that the judge conscientiously executed the necessary sentencing exercise and conveyed his reasoning to the offender and co-defendant with great skill. We do not find that the sentence imposed was unduly lenient. We dismiss His Majesty's Solicitor General's application. We now turn to the application for permission to appeal against sentence. We make the obvious point at the outset. The guideline on sentencing children and young people does provide that when sentencing children or young people, a court must have regard to the principal aim of the youth justice system, which is to prevent offending by children and young people, and the welfare of the child or young person concerned. However, these principles do not undermine the fact that the sentence should reflect the seriousness of the offence. This was a very serious offence. As we have indicated, we find no error in the judge's assessment that culpability was high. We are not persuaded that the judge wrongly identified or analysed those aggravating factors which he listed. His sentencing remarks display a conspicuously fair assessment of all the circumstances. There was evidence that demonstrated the significant physical suffering caused to Mr. Kohli by the attack. The judge described him as in agony. The offender could not have known that Mr. Kohli was osteoporotic and in 2017 had suffered a wedge compression fracture requiring surgical intervention, making him far more at risk of further spinal injury. But it would have been obvious to him that Mr. Kohli was vulnerable, and we observe particularly so following the second push to the ground, after which the offender kicked him to the body and caused 3 fractured ribs. The use of the balaclava was obviously intimidating and intended to conceal identity, and whether done for the first, less injurious attack does not diminish this aspect of planning. The judge tempered his assessment of the use of the shoe as a weapon being used to humiliate rather than to cause physical harm, but that the offender was the prime participant in the attack and assumed the mantle willingly. As we have indicated, we are not persuaded that the judge disregarded the relevant guidelines principles of sentencing young people. There was evidence that this offender's maturity was commensurate with his chronological age. The judge recognised that the offender's behaviour probably had been affected by, quotes, emotional volatility, end quotes, in his upbringing and possible, quotes, negative influences, end quotes, of his peer, as indicated in the guideline to which we have referred. The judge's approach was individualistic, see guideline 4.30. The sentences imposed reflected the vagaries of the offender's youth and previous life experiences and was reduced to 1/2 of that which would have been appropriate to an adult. Guideline 6.46. The judge's assessment of the offender's racially offensive reference to Mr. Kohli's ethnicity was nothing but measured. That he assessed this to increase the sentence by an extra 6 months does not render the sentence manifestly excessive. The sentence was a very significant sentence, and necessarily so. It was entirely warranted by and commensurate with the seriousness of the offence. It is simply unarguable that the sentence was manifestly excessive or wrong in principle. We therefore also refuse the application for permission to appeal. Anything arising, Mr. Bartier?
Perfect.
Mr. Jarvis?
Nothing, my lady. Thank you.
Thank you very much. Oh, sorry. Do you want to dismiss the defendant before we go? Sorry. we rise, in fact. We wish to express our genuine condolences to the family of Mr. Kohli, who have experienced such a devastating loss. The photographs of Mr. Kohli that have appeared in the press accurately reflect, we may say, what was obviously a sunny disposition and a genuine enjoyment of life, his family, and all of that which he did. It's a loss that will be hard to bear.
Thank you for those words, Milady.